starting the recording and letting IT know we can start. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-5028, Washington Alliance of Technology Workers, Appellants versus United States Department of Homeland Security et al. Mr. Miano for the appellant, Mr. Press for the government appellees, Mr. Hughes for the association appellees.
Mr. Miano, thank goodness we can see you.
Thank you. We've had some technical problems. The building has basically lost its internet, so I'm sorry we're having to do it with the phone. We may lose the video.
Okay, well, we can hear you. So
Thank
please
you,
proceed. Okay, please proceed.
May it please the court. The statute at issue of this appeal is very clear. In fact, it is so clear that until now it has never suffered from conflicting opinions in the courts. The student visa authorizes admission of bona fide students solely to pursue a course of study at an approved academic institution that will report termination of attendance. Those are the requirements for student visa. Yet DHS has disregarded those requirements to transform student visas into the largest guest worker program in the entire immigration system by allowing aliens to work in the United States when they do not conform to those requirements. The regulation at issue is in excess of DHS authority for two reasons. First, it allows aliens to remain in the United States when they're not pursuing a course of study, and it allows aliens to work in the United States while not pursuing a course of study. And the practicable effect of this is that DHS has created its own H-1B program through regulation that circumvents the caps on H-1B visas that protect American workers.
Mr. Miano, could I ask you to just pause for a minute or two and focus on the government's argument that your association lacks standing? If you don't mind, would you focus on that? And maybe you could start by telling me, for you to have standing at the summary judgment stage, you have to show that a member of your association is competing with OTP workers, right, who are not attending school, who are subject to extensions. So could you point the court where in the record that, what is your best evidence of that?
Best evidence of that, Your Honor, is one, that this regulation is targeted to the tech industry. So the workers coming in here are specifically targeted to the tech industry, and we have it, the plaintiff is a union of technology workers.
Right, but under our decision in Mendoza, if you want to make that argument, you have to show that one of your members is, quote, a direct and current competitor whose bottom line may be adversely affected by the challenged government action. That's a quote from the case. So where is that evidence in the record?
The evidence in the record, Your Honor, is that the workers in question here are working in the tech industry. They're currently active workers. And in the case of Mr. Smith, he's a temporary worker, so he's continuously searching for work. But the standard
Mr. Who?
in the Mr. Smith, he is a temporary worker. The novel argument that the government raised was that now that two of the named members of the association are now that two of the named members of the association are employed, the government's argument is now that they're no longer competitors, that they're no longer in the industry. The standard for competitive standard is whether the regulation at issue allows competition against them. And Louisiana Energy, and this court has repeatedly held that a party suffers injury in fact if competition is allowed against them. And in this case, it's not even allowed; it's directed towards them.
Let me ask you to, in response to your in the district court, in the appendix that you filed in support of your motion of summary judgment, you had a very helpful table listing all of the allegations in support of standing. Do you know what document I'm talking about?
Yes, Your Honor.
Okay, so and you have two columns there. You list the allegations and then the evidence for each one. And as I go through it, next to every one of the allegations, which claim that applications had been made for OPT extensions for workers in companies where your members applied for jobs, there's 27 of those. It says there's no evidence.
That 27. I'm to look up here what you're referring to.
I'm looking at your chart where you have. I didn't write down the numbers, but there are 27 different allegations which claim that applications were made for OPT extensions for workers in companies where your members have applied for or jobs or are working, and each one has this statement that there's no evidence because it's in the hands of the department.
Right, Your Honor. Okay, now I see what you're talking about. Yes.
So that what's your, given that we're at summary judgment here and you have to actually prove standing, we're not at the motion of this stage anymore. What does that table mean to you?
Your Honor, what the difference is here is that we're now talking about specific job losses, and that's a concept this court has repeatedly rejected. You don't have to show specific losses of sales, but rather you have to show that competition is allowed against you. And in this case, we're talking about a program that allows over 200.
Are you talking about? Are you referring to Mendoza?
No, I'm not referring to Mendoza. I'm referring to like Shirley versus Sibelius. That is really Sibelius. The standard is that says that the issue isn't lost sales per se; it's the allowance of competition. And so we have more competitors in the market. You add 400,000, you add 200,000 competitors into the technology market, in the U.S. market. You're affecting everyone who's in the market. Now, I mean, in theory, that would, people might say that that's a generalized grievance, but we would flip around and say is that when DHS does something as broad as this, where it's adding as many foreign workers, it injures more workers.
I thought this Mr. Sawade, I'm not sure, Sawade, I thought his affidavit was more concrete. Mr. Miano.
Yes, Your Honor. We different how the people specify them, what they do. But Mr. Sawade has worked in the tech industry. He's been laid off. He's worked as a temporary worker, and now is back working full time. And all of this has occurred during the course of this litigation. So we're now, so we have these workers who are, they're applying for jobs, they're working for jobs, and these are just representatives of an entire union that represents tech workers.
All right, Judge Tatel, do you
No.
does that answer your questions on standing?
No, but go ahead with.
Well, I mean,
I don't have any other questions.
All right, okay, go ahead.
I had a broader question on standing. I do see the logic of your position that competitor standing. The premise of it is, if in the business to business context, if a regulation eases restrictions on one business, that harms a competitor, and in Mendoza, if immigration law gives a opportunity for people in a field, animal herding, that is going to change the employment prospects of domestic animal herders. And I'm not sure that I see an outer bound, but it is, when you get into a field like STEM, which is very diffuse and large and ill-defined, it does seem like the implications of our case law, which of course is on us, are that any working person in the United States would have standing to challenge any immigration law that affords worker permission, that authority to work, to people coming in. And I'm just wondering that seems like generalized just standing, and whether you have any help for me in thinking that through.
Well, like in the Shays versus FEC case, basically, it said that anyone had standing who was in the electoral field, okay? Because a generalized grievance has two parts. One, has to affect a lot of people, and two, it has to be a nebulous injury, okay? Here, we're not dealing with a nebulous industry. Increased competition, the allowance of increased competition has been treated as a concrete injury by this court consistently. So that takes it out of the range of a generalized injury.
Well,
And
even
plus,
there, though, Mr. Miano, the brief of the tech companies make a point that I think is economically supported by at least some evidence, which is that certain tech workers may not have a net negative effect on employment, but in fact a net positive. If you bring in people who have key skills that will allow a business to do something, they may need more workers to come together and accomplish that they couldn't do at all without the kernel of knowledge workers. And so then it becomes a question of, well, whose burden, and none of that is in the record. But it isn't always clear that adding worker A to the economy depresses opportunity for worker B. And I'm not sure how to think about that.
Well, Your Honor, that concept has been rejected by standing Supreme Court, that we don't take benefit, the benefit to diminish the injury. Plus, we would argue that those study claims are fallacious. I mean, they fly in the face of the basic law of supply and demand. And the problem that we're facing in the tech industry— I'm
sorry, you referred to the Supreme Court case saying we don't take the benefit to diminish. What case are you thinking about?
I can't think of the case right off the bat, but that was the argument that was used in Texas versus the United States in the DACA case, where the defendants argued there was no injury because for having to provide driver's licenses because they're getting payment, but the courts rejected that because they said there's not a plus or minus. It's like basic trespass law. If someone comes on your property, sees a piece of trash in your property and walks over and picks up the trash, you've still been injured by trespass, even though you suffered a benefit. But the problem that we're facing in the tech industry is Americans are being displaced. I mean, physically one for one displaced. So what's being told, is it creates this benefit. But when you're working in the industry, for example, Judge Tatel heard one of our cases where we have Americans that have literally been replaced by H-1B workers, by foreign workers being brought in. And these, unfortunately, in the H-1B program, the only protection for American workers under H-1B is limits on the number of workers. So like Disney can go in and take two.
Were you referring to Save Jobs? Is that the case you were just referring to? But in that case, there was actually evidence that its members had affidavits saying some of them had been fired and replaced by H-1 workers. I mean,
yes, they've been fired.
Right. You don't have any evidence like that here, right?
No, these people, it's just standard plain vanilla competition where the standard of injury.
But you see, I think the point Judge Pillard and I are both probing here is that the quote plain vanilla may not work at summary judgment. And I'll just go back to read you. Mendoza says you need direct and current competitor. You have to show that one of your members is a quote direct and current competitor. Direct and current competitor.
All right. And I would point out that in Save Jobs USA, the court says the department overreads our direct and current competitor formulation, which simply distinguishes an existing market participant from a potential and unduly speculative participant, and then goes on to say, we know that these H-1B visa holders have competed with Save Jobs members in the past, and as far as we know, nothing prevents them from doing so in the future. If that's good enough for H-1B, I don't know why it isn't good enough for F1.
Yeah. Well, thank you. I mean, that's basically our position. But and I'll give you two different. One, in Mendoza, these are people who are just wanted to get into the business. In this case, this is a unit of people actually in the business. I mean, these aren't people who are speculative. These are computer programmers, network people who are actually do it. And getting back to the generalized grievance type thing, I mean, what we have is suppose DHS does a regulation to import foreign butchers, okay? In theory, only the butchers would have standing to challenge such a regulation. If they then have a regulation for bakers, then only bakers would have regulation. But when they start having butchers, bakers, and candlestick makers, increase the number of fields that are eligible, it seems to me they're increasing the number of people who have standing to challenge it. So if they say, hey, we're just letting tech workers in, which is main part of this regular extension is tech workers, you would think only tech workers. If they said this regulation could apply to anyone, then effectively it would sound they're opening standing to the entire world.
Mr. Biano, you've used up your time, unfortunately, on standing, but let me give you, since I think you're the only one challenging, I don't think the association is, why don't you take at least 3 minutes to address the merits?
Well, Your Honor, the problem with the merits here is that we have a very clear very clear statute that has never had any problem with interpretation that says that we have to have bona fide students pursuing a course of study at an academic institution. Instead, we have people we're calling students who are working after graduation, have no connection to a university, they're not attending class, they finished their course of study, and DHS has taken it upon itself to create a guest worker program to allow these workers to provide labor. And in fact, the regulation that this litigation was explicitly designed to increase the amount of labor by substituting to circumvent the quotas on H-1B visas. And so,
Mr. Biano, in your view, is the graduate who stays in the United States for a couple of months after graduation out of status and deportable the day after graduation?
Your Honor, what you've now hit on, I guess, runs into what Einstein's theory of relativity, that we can't have instantaneous movement. And I think that creates the type of gap that Chevron doesn't even exist. What happens when Congress creates something that's impossible? So I thought they had 60 days
to leave.
But not under the statute, only under the regulation. Is that right? And the question is, what's the statutory support for that regulation?
Well, what I would say in that case, and we're getting into theoretical, but Chevron is kind of a one size fits all. And what we have there in what you've described, the statute creates an absolute impossibility for the agency. They can't leave the next day and instantly be gone. So in that case, there's certain discretion. How I do it? And DHS has said, okay, you can leave get 60 days and you can leave.
But really, I mean, it seems like on your theory, the student who is, that students should be applying for tourist visas for any day that they plan to stay after graduation, and that the rule under your theory, the 60-day rule, is a statutory violation, and that maybe the Homeland Security will have a prosecutorial policy where it won't go after students. I mean, why would it if they're heading out of town, out of the country? But the rule the statutory authority for that rule, doesn't that rise and fall on your theory, just like the OTP rule would have to rise and fall on your theory?
I don't think so, Your Honor, because what you're, unfortunately, in the immigration statutes, there are a number of absolute impossibilities that Congress has enacted. I won't go.
But it's not an impossibility. You schedule a flight or get a tourist visa. Why is that a possibility?
Well, you schedule a flight to be in, oh, I've got my degree, we'll move. And I think there's a big difference between giving someone time to actually leave the country, you know, for a modest period of time to leave the country is entirely different than allowing them to stay for 42 months so they can provide labor to Microsoft.
Well, and as a matter of fact, they are allowed to stay in the summertime between years of study, and they're not necessarily pursuing a course of study. If there are no more questions, then we'll give you a couple minutes in reply, Mr. Miano. Mr. Press.
Thank you, Your Honors. Joshua Press from the Department of Justice here on behalf of the government at police. Your Honors, we think that this is a simple case for two principal reasons. One is the questioning of Mr. Miano was sort of getting at. The standing questions do linger in this case, and it is different from Judge Tatel's opinion in Save Jobs, simply because at no time have the plaintiffs, or the rather WashTex members, actually shown that they were in direct and current competition. We know from Judge Henderson's opinion that, you know, at the motion to dismiss stage, they did have standing because of their allegations that they were still searching for jobs and the complaint. But at the motion for summary judgment stage, as this court has made pretty clear numerous times, including in Humane Society, which we cite to and discuss in our briefing, at the summary judgment stage, the burden is greater upon the plaintiffs, and that's why we made the argument that we did.
Mr. Press, why isn't it enough, as Mr. Miano's briefing asserts, that the people who are in jobs, his members who are in jobs, that presumptively their wages may be depressed by the existence of the program? So it's not just about competition for job openings, it's also about the conditions of the job that one has. If there are people who are eager to get it on weaker terms of, you know, supply and demand, isn't it sort of presumed by the law of economics that they're harmed even if they're employed?
Well, I think that's a good question, Your Honor. I think the problem for that, with that argument, though, is that courts don't typically presume things for the purposes of standing. Now, I will admit the law of economics does come into play, and that's why the competitor standing doctrine exists. But I think this court's case law has been pretty clear that that's why there is a need for direct and current competition. If you simply look at the affidavits that were filed by WashTex members, they really don't talk about anything that Your Honor's question is getting at with respect to depressed wages. They talk about, I've applied for these jobs and I didn't get them. I think the difficulty there, and I mean, we're sympathetic to that, but the difficulty is when you're talking about the actions of third parties and their decision-making process as to whether they hired or not someone who interviewed for a job, you're falling directly into the Lujan versus Defenders of Wildlife, much more is needed category to bridge that gap and fill that presumption that Your Honor's question is sort of getting at. I mean, with the wages issue, I can just tell you that there's really nothing in the record about that. So it's really all about what Mr. Miano was getting at of, am I being replaced by a foreign student or an international student under the OPT program? There is nothing in the record about any sort of replacement theory as there was in Save Jobs with Judge Tatel's opinion there.
What's the defect in, Mr. Marino mentioned an affidavit by an employee named Saud, S-A-W.
Right. So I think,
what's the defect in that affidavit?
So with Mr. Sawadi's declaration, I think the issue there, no problem. And that's how, I hope that I'm pronouncing that correctly. Mr. Miano can certainly correct me if I'm wrong. But I think with Mr. Sawadi's declaration in particular, he never actually alleged. I think the last time he got a full-time job was in 2018, and that's it. That's all we know. He started in June 4th of 2018. I think that's at JA page 215 in the appendix. And the problem that we had with that was that when we moved for summary judgment was in about 2 years ago. So it was in fall of 2019. And essentially, we had not heard of anything about Mr. Suwade's employment search or career path or anything like that for over a year at that point. And so we thought, well, that doesn't actually get at current competition. That's past injury. And because the words are direct and current, as Your Honor was pointing out before, that places an emphasis on the present tense, not future tense or past tense, perhaps immediate future for purposes of typical standing analysis. But there's nothing in the record about presently he was being affected or that he was actually looking for a job.
What
Now,
about,
yes,
no,
please.
finish. I'm sorry.
Well,
Finish.
Mr. Miano might sort of, and he has in previous iterations of this litigation sort of argued, well, in our complaint, we say that our job search is constant. But I think the problem with that argument, as Judge Pillard was getting at, was that when you're sort of opening that up to, I'm competing with literally everyone in the science, technology, engineering, and mathematics field, that is extremely similar to taxpayer standing. Because what we're really saying is, as long as someone wants to get a job and foreign students or international personnel might come in and take a job, therefore I have standing to challenge that entire
All right, and
immigration reg.
and why
This may be an
haven't,
issue. Go ahead, Judge Henderson.
all right, and why haven't we said precisely that in Save Jobs USA when we've said, in this case, we know that H-1B visa holders, you can substitute F-1, have competed with Save Jobs members in the past, and as far as we know, nothing prevents them from doing so in the future. And the language about, in the same case, the department overreads our direct and current competitor formulation.
So I think that is a good question. It's interesting because there's sort of an echo effect between this case and that case. And because that case does cite, I think, to Your Honor's opinion, from WashTech at the motion to dismiss phase. I think the distinction truly is that there was already evidence in the record at the summary judgment phase in Save Jobs of direct job loss by one of the competitors. And I think that's sort of the problem here is we have no evidence of anything like that. It's much more diffuse. And second, there's no evidence that they're currently still looking for a job. And I think, yes, please.
I was just going to say, I think the standing issues are kind of a problem of our creation, and we will have to address them. But I'm interested in your position on the merits.
Yes.
How typical are, I mean, you defend this provision on the ground that it is the seeks to enter language means that the conditions of these visas are assessed at the outset, and that after that it's sort of up to the to DHS to put conditions and both of time and activity. Are there how many other provisions are in the seeks to enter form, and would the effects of your position be limited just to those?
I think that well, first I'll try to answer the first question. I don't actually know the number of definitions that sort of use that language. It's really alphabet soup when it comes to the different status and categories of visas that foreign nationals can choose to pursue. I do think that, if you look at just a typical example, a B visitor, they're seeking to enter, for a temporary period of time for pleasure and or temporary business purpose or something along those that nature. There's language that specifically bars them from working when they're trying to get into that category. I think the reason why we were making that argument that this is going to admissibility determinations is because, number one, when a foreign national needs to get an F-1 visa, they have to go to the State Department in a consulate, and they have to show, hey, I'm enrolled at this university or at this school, and I want to take these types of classes. And they have to prove to the consulate that they really are going to be a bona fide student. Then they have to come in to a port of entry and they have to talk to a CBP, Border Patrol, or Customs and Border Protection officer at an airport or something like that, and say, I got the visa that from the consular officer. Here are my papers from the school. I'm really excited to be here. I want to go to class, etc. But once they enter the United States, once they're admitted into the United States, obviously things can change once we're going through college classes. I mean, I don't think it's unusual for college students, for example, to change their majors or to change what they're interested in or their pursuits while they're attending classes. And as part of that, things happen once they enter. I can tell you that, and I think the case law.
If a student gets mono and just says, I'm not going to be able to do well, I need to take a break. Is there any regulation that defines how a person who drops out or takes time off is dealt with? Yes.
So if I might, because I'm probably going to exceed my time, I hope that I can answer your question in full. Very quickly, in that scenario, that came up actually in the 1926 or the 1928 Northern District of California case that we talked about in our brief. Whether he was that student was a bona fide student, even though he got sick and had to drop out while working at a newspaper in San Francisco. And the question was whether he was deportable and whether we should just leave him, kick him out immediately, as Mr. Miano's position would have it, because he was no longer a student. And the issue there was, no, he was still a bona fide student, and the case law is replete that that's what the term bona fide student means, because there's a good faith intent to continue with the studies. Now, number two, in terms of if they do stop taking classes and they stop pursuing a course of study, at that point they are out of status, and the regulations do sort of require them to either leave or to resume their studies.
So that statute is very oddly written, and it seems like both sides have some challenges. But under your theory, the statute primarily addresses the student's status at the time that they seek to enter. Do they have to then be a bona fide student? Like, reading it the way you do, in fact, reading the literal language, it sounds like an alien who's living, having a residence in a foreign country, who is a bona fide student qualified to pursue a full course of study. So who already is in school of some sort, and then is qualified to pursue it and seeks to enter the United States for that purpose. So what if you're not a student and you want to come to the United States on one of these visas? The statute literally read seems to foreclose that.
Well, I think Your Honor is correct that if we read this too literally, it sort of doesn't make a lot of sense in a lot of different circumstances. That's why, to be perfectly candid about this, the statute has never been read so literally as to strangle its meaning. It's always been read functionally to mean that if you are coming here to go to a school and attend classes and to do work study even, and I think the work study stuff is really discussed at length in all of the briefings in support of the government's position. Then you can come in, we will let you in to pursue that course of study. Obviously, that's supposed to be at a university, but you don't have to attend the university immediately or already be in the university. It's simply having proof that you've been accepted to attend those classes and to start your course of study is adequate.
And there may be some difference between you and Mr. Hughes on this point, but you're not arguing that we can read the statute itself without deference to support your position? You need Chevron step 2? Well,
I think we have made that argument implicitly. I know that sounds like a cop-out, but I think that the reason why I say that is because the entire ratification doctrine is really an interpretive doctrine of the statute. And Mr. Hughes's brief and mine really look to the exact same history in that the point we're making is the statute has always been interpreted this way. Mr. Miano said that Congress never had a problem with interpretation and courts have never had a problem with interpretation. He's absolutely correct about that. And the reason why I know that he's correct about that is because at least since 1947, the statute has always been interpreted to allow for practical training, including practical training after graduation, which it seems is the main beef that Mr. Miano has.
Do we know that at the original adoption of the INA, do we have evidence that before its adoption under the 47 Act, that some of the practical training was post-graduation as opposed to during school? What's your best evidence on that?
So I truly think that the 1950 Senate report discussion that is really, we get into the guts of it within our brief. I know Mr. Hughes' brief gets into the guts of it as well. That is the best evidence of that, because that is an acknowledgement by the Senate that this is going on after graduation and that we are not changing it at all. We are not changing the language. I mean, honestly, to your Honor's point with respect to why the language is written this way, it's because it's vestigial. I mean, it is a lot of this language has been around for basically since 1924. And I know that's not a century, but that's pretty long. That's a pretty long time.
Right, Mr. Press,
yes, sorry.
Go ahead, finish your thought.
Well, I was actually going to conclude. So
all right,
please.
well, I have a question for you. And that is, considering our precedent from 79, this ANWO versus INS, which interprets this intent of not abandoning the foreign residents as a continuing requirement, what, if anything, do you require the alien to show that he has no intent of abandoning his foreign residence? And is it a continuing showing he makes?
Well, I think that is a good point. I think that determination gets made at the port of entry when someone is being.
And how? With forms or what? An affidavit?
Yes. I think it does. It does. Forms obviously are necessary both with the consular officer when they're approaching a consulate and asking for a visa to allow them to apply for admission in front of CBP, and then again with the CBP. And to take your Honor's point, to answer your question directly, they have to show, hey, this is my current path. These are the studies that I'm going to be taking. This is how long I'm going to be taking the coursework, or at least presumably, because I think, as we all know, sometimes, well, I knew personally that sometimes I take more classes for a longer period of time than I initially set out to take. You're correct.
Do they swear that they're not abandoning their foreign residence? I'm just trying to find out how you established intent.
Well, so that is a good point. I think, honestly, the reason is that that's not a problem is that because there is a presumption built in both before the consular officer and the CBP at any port of entry that the person is trying to come in with an intent to remain here indefinitely.
Well, where does the presumption come from?
Honestly, it comes from the definitional definitions of immigrant versus non-immigrant. The problem with that and why it's quirky is because non-immigrant is not really defined. It's only defined in the negative of someone who's not trying to come in to remain here indefinitely. And so therefore, I know that is extremely frustrating. I apologize. But what I can tell you is the way that this works in practice is that CBP and consular officers always presume when someone is approaching them saying, oh, don't worry, I'm just coming in to see Disneyland and I promise I'll leave immediately after that. The way that they presume and try to deal with this problem that Your Honor is getting at is they say, well, you have to prove to me that you are going to leave. I mean, you can't just say that. I mean, obviously saying that is helpful because we do presume that they're telling the truth. And I don't know if there's an affidavit or any sort of declaration that they have to swear to. I apologize for my lack of knowledge about that specific point, but I do know that they have to show documentation. They have to back that up with some sort of evidence that fits their story. I also know that when they drop out, and this is the other weird thing about the F1 program, is that if they drop out or if they stop attending classes, as Judge Pillard's question was getting at earlier, then the school itself is required to report that within the SEVIS system. It's the Student Exchange Visitor Information System. That's extremely important. Congress really cares about that. That was added in 2002 because, frankly, some people were, some of the September 11th attackers came in under this program and really, obviously, were not students. And because of that, Congress cared about that and put that onus on the universities to report students who were not complying or were not going to classes because at that point they were out of status. And at that point,
as a policy matter, that makes sense. But Mr. Miano points to that to say, well, doesn't that imply that the statutory test is not applicable only at when the person seeks to enter, but has an ongoing, applies during the entire time the student is here. So he says that the very fact that you're verifying and asking for reporting and, means that the statutory language requires that the person that, it's not just for the purpose of pursuing such a course of study, but that it is only for the duration of that course of study.
Right, and I know that that's an argument Mr. Miano makes. I think the distinction is that onus is not at all on the international student. The onus is on the universities and programs that subscribe to the F1 program. They are the ones who have to update the database. If we put the onus on the student and it's somebody we don't trust, frankly, I don't understand why we would let them update their status and tell the United States government, oh, don't worry, I am going to class. That's why it's directed to, and it regulates not any of the F1 international students, but the universities themselves.
And is that pursuant to the DHS general authority and not pursuant to the F1 authority? Is that where?
Correct.
Okay.
And that is in terms of conditions, and that is sort of once they enter into that program, the universities or the institutions, this is something that they have to do if they want to remain in that program. For example, the penalty there is not. I mean, the students aren't penalized if the school screws up. At least by the United States government, they're not penalized. It's the schools, and they might lose their ability to enroll international students if they do not comply with that provision or do not update CETUS.
All right, any more questions?
No.
All right, then we'll hear from Mr. Hughes.
Thank you.
Thank you, Your Honor. Paul Hughes for Applees, the National Association of Manufacturers, the U.S. Chamber of Commerce, and the Information Technology Industry Council. Post-completion practical training has existed since at least 1947 for 74 years, and we ask the court to emphatically reject WashTec's efforts to have the court end the program. At the bottom, America thrives by attracting international talent to our universities, and DHS was authorized to determine that those students appropriately may complete their studies through limited practical training. We think the way to understand the legal question, the authority here, is to begin with Section 1184A1. That's a very important statute that expressly authorizes the secretary to, quote unquote, prescribe regulations that govern the, quote unquote, time and conditions of a non-immigrant's admission. This is a broad grant of authority to the secretary, which is consistent with the executive's substantial immigration powers. In light of that broad delegation of authority, the question in our view then, is there anything that precludes the secretary from adopting the OPT program? And we think the limitations can be found in two different places and that put guardrails on the secretary's Section 1184A1 power. One would be is if there's a textual preclusion of the conditions that the secretary would seek to implement under Section 1184A1. And we don't think that F1 has any textual preclusion of this program, and I described that. The second is that in exercising the secretary's 1184A1 power to adopt conditions governing the stay of non-immigrants in the United States, those conditions have to be reasonably related to the underlying purposes of the statute the secretary is implementing, including the various visa definitions. And I think that's a very important limitation in this context, because there's no doubt that the secretary has broad powers in this context. And one can think of wild hypotheticals that would suggest a rogue DHS would allow somebody who comes in on a tourist visa to remain in the United States for 50 years and all those sorts of things. But what precludes that is that all of those sorts of wild hypotheticals would not be reasonably related to the underlying purposes. So we think the question—
Mr. Hughes, it seems like the current regulation is done in a better way to meet the kind of nexus with the statute that you're describing, which is describing OPT as part of an educational experience, and that has to be recommended by the schools, and there has to be oversight by the qualifying employers and the like. But the prior iteration of the rule was all about U.S. competitiveness, wasn't it? And would that be supportable under, if that were still the frame and the nature of the rule, would that be supportable? And if not, how do we sort of deal with the pretext issues of that that being the first stab, and this much more education oriented rule being the current?
Well, so a few responses to that, Your Honor. First, just as a functional matter, the rule that's currently before the court is the 2016 OPT rule. The challenges to the 2008 rule were found moot, and that's not before the court. The 1992 rule is also not directly before the court. It's only before the court by implication of the 2016 rule. The second point is, as the Supreme Court instructed us in Department of Commerce, looking behind the purposes of the rule would require some sort of extraordinary, exceptional evidence of bad faith or bad intent. And I don't think there's any such evidence or argument that has been made here. So then the question is, well, what is in this rule? And DHS in 2016, as the court indicates, provides a very robust a record that is before the court that I think more than sufficiently supports the rule. I think that's consistent with greater scrutiny that courts have provided regulations today than perhaps they had in prior decades. So DHS in promulgating this rule was aware of current judicial approaches and was ensured that it effectively did its homework in extensively documenting how a term-limited practical training program directly relates to the completion of the student's education. And we pointed to the extensive parts of the record where DHS makes those findings. I'd also point the court to the evidence that DHS relied on at JA 174, 148, comment letters that say that extensively. As for the duration of the program, the 3-year duration, for example, DHS also made very extensive findings that show the reasonableness of why 3 total years is reasonable. For example, at JA 182, the comment letter of the Society for Human Resources Management says that this is comparable to training programs for postdoctoral students in the 3-year period for the National Science Foundation. And other evidence.
But none of those programs are required for for American students not requiring visas. They're not part of any educational program for US students.
The purpose
Unlike, for example, internship and residency in medical school.
Well, Your Honor, I think what the DHS was just pointing to is why did they draw the 3-year maximum limitation? And they did so because looking to the National Science Foundation grants, PhD programs, and then also there's extensive evidence around J 127, 130, 133 that the life cycle of one project for a STEM student doing an integrated circuit design, for example, is often going to be around 3 years. So to get back to the statutory questions, as the court pointed out, it's been uncontroversial that DHS, as part of the regulations, may allow an individual to remain in the United States for up to 60 days post-graduation as part of their F1 visa. Well, why can they do that? Because it's not inconsistent with the statute as we understand it. And second, it's a reasonable regulation that effectuates the purposes of the statute. For the same reasons, we think OPT is not precluded by the statute and is a reasonable interpretation. Second, looking towards the history.
Doesn't your reading, though, read out the word solely in the statute? You can quibble about whether it reads out temporarily. 3 years, I suppose, is temporary, but why doesn't it read out the word solely or the words solely for the purpose of pursuing such a course of study?
Your Honor, because we think that is appropriately described as the entry requirement. That's what is required.
Well, let's say it isn't. Let's say it isn't. I don't buy that, let's say.
Well, Your Honor, I think there's still some flexibility and understanding of what means to be a student. So let's take, for example, an individual who falls in love and marries somebody and adjusts their status. So they entered the United States as a student, but then they adjust to a K-1 visa following a marriage. That is often permitted and allowable in our immigration system. And that individual, even though the individual who entered solely for one purpose ultimately had some sort of change at a later point. But Your Honor, the textual language there, who seeks to enter the United States temporarily and solely, truly we think is best understood as the entry requirements. And I agree that language is very important because it does put parameters on what is reasonable for DHS to adopt as a regulation. So we think it would be patently unreasonable if DHS were to promulgate a regulation saying somebody who enters with that intent, but a week later decides they don't want to go to school, they'd rather do something else, they drop out, and they're not furthering their education. If DHS were to enact that kind of regulation, we agree that that would be not reasonably related to the underlying purposes of the statute, and that language that the court is pointing me to certainly defines what is in the range of reasonableness that DHS could adopt in promulgating regulations that further the purposes of the F1 statute. So I want to be clear, we don't think that language drops from the equation at all. It is an important part.
I realize that. Are there any more questions? All right. Let's see, Mr. Miano, we've lost you, but I assume you're still on audio. Why don't you take 2 minutes and reply? We must have lost him altogether.
Judge Henderson, Mr. Miano's phone connection has just dropped. I am calling him again.
Okay.
Your Honor, can you hear me?
Yes. Okay. Why don't you go ahead, Mr. Miano, and take 2 minutes and reply?
Okay, let me just go quickly, Your Honor. First of all, DHS in standing has switched this from allowance of competition to lost sales. So I would point out Bristol Myers Squibb versus Shalala, as showing where this court distinguishes between lost sales as an injury and says that lost sales is not the actual injury, but it's the increased allowance of competition. In regard to the long-standing use of this program, ratification here isn't even applicable because your opinion dismissed your WashTech opinion dismissed all the counts except for excessive authority. So we're talking just excessive authority here. So I mean, ratification is not even applicable. In regard to Section 1184A, we seem to be forgetting the key part. Is 1184A requires DHS's regulations to ensure aliens leave when they do not comply with the status for which they were admitted, and that seems to have completely gone by the wayside. And I would also like to address the wild hypothetical.
But both the government and the intervener emphasize the words "seeks to enter the United States." They say that's an entry condition, and if that's right, I realize you may disagree with that, but why is that an unreasonable way to read the statute? Because if that's a reasonable way to read the statute, that solves that problem, doesn't it?
If it were a reasonable way,
okay, but why?
Tell
me why it's unreasonable to read the statute that way. Seeks to enter.
It's because, Your Honor, it's because of 1184A, which says that you have to maintain the status for which we're admitted. And if you were to take that language for any other visa, you could say that all of them are entry requirements. The tourist visa, you don't prohibit those people who enter to perform labor. But if you, they could say, hey, we've entered, and so now we can allow you to work. And this isn't a wild hypothesis either, because the State Department is already doing this. It just has not been challenged yet. And the key thing is that this sets down the visa requirements, and they, in every court case ever looking at student visas or any non-immigrant visas, have treated the requirements as applying for the alien's entire stay. And there's a huge number of cases dealing with student visas. They're not dealing with question whether of the legality of regulations, but they're all treating student visas as the requirements applying from start to finish.
All right. Thank you. Madam Clerk, would you call the next case?
Case number 20-7114, Ramona Matos Rodriguez et al. Versus Pan American Health Organization, appellant, Joaquin Molina et al. Mr. Boker for the appellant, Mr. Dubin for the appellee, Mr. Yellen, amicus curiae.
All right, Mr. Boker, good morning. Please proceed.
Good morning, Your Honor. May it please the court, David Bowker, especially appearing for PAHO to assert its immunity. The Supreme Court's decisions in Sachs and Nelson and this court's decision on remand in JAM v. IFC all require reversal here under the IOIA. Those cases demonstrate that the district court misidentified the gravamen of the 1589B claim and thus wrongly concluded that the gravamen of that claim constitutes commercial activity. Sachs, Nelson, and this court's decision in JAM all instruct that the gravamen of the claim or the gravamen of the action is the conduct that it is based upon, the core or foundation that it is based upon. Here, that core, that foundation is forced labor and trafficking.
And I take it, Mr. Bowker, that your position on that would be the same if Matos had only brought the one TVPA claim under 1589B, just benefiting from trafficking or forced labor, that even that claim, which is about economic benefit, and which I don't think you dispute, that benefit is taking place for PAHO in the United States, that nonetheless the gravamen of that claim would also be in Brazil.
It is correct that the gravamen of that claim alone, standing alone, would be forced labor and trafficking. And the reason is the language of the statute refers to knowingly benefiting from participation in a venture that's engaged in providing or obtaining forced labor. And the title of that section for both 1589A and 1589B is forced labor. And if we look at the complaint, the count that makes the 1589B claim says, quote, that PAHO knowingly benefited financially from trafficking of plaintiffs in violation of 1589B. And it says that.
So, I mean, of course, so what you're saying is that there has to be proof of the trafficking of the plaintiffs,
Right.
and that's why the gravamen is trafficking?
I think it may even, I don't think it turns on a single element that way, that you need to establish each element and that we're focused only on one element. Rather, we're following the direction of Sachs, Nelson, and this court in JAM v. IFC, which directs us to look at the foundation of the suit.
Just putting aside the Foreign Sovereign Immunity Act issue for a moment, if medical suppliers are us, a U.S. firm, sold, bandages, thermometers, stethoscopes, stretchers in the U.S. for a profit, and it was proved that those goods were manufactured abroad by forced labor, seems like there's little question that that American business would be liable under 1589B, right?
I think that's right, Your Honor. But there, obviously, you're not dealing with the FSIA or the IOIA.
So if PAHO were doing the same thing, we're selling those same goods that were produced overseas with trafficked or forced labor, and PAHO were aware of that, in your view, that is not enough for that exact same claim to be brought against PAHO?
I don't know that. I don't think that's our position, Your Honor. The position would be instead that what's alleged here is PAHO's participation for purposes of 1589B. PAHO's participation is much broader than moving money. And in fact, there is no allegation that PAHO was moving money for a fee. The allegation here—
like that's a proof, that's a merits issue or a proof issue, a summary judgment question. It's not a question for us at the threshold.
I think it's a pleading issue, and the pleading issue is as follows. What matters for the foundational purposes of 1589B is what is the foundation of the claim? We submit that the foundation is forced labor and trafficking because that's what the provision is all about. Even if plaintiffs and the district court are right that the foundation is PAHO's participation, in that case, the participation is much broader than moving money. And in fact, the fee here that was charged, the pleading The complaint says the fee was charged for medical services, for brokering medical services, triangulating healthcare services. In paragraph 38, paying PAHO fees for the doctor's labor. That's obviously a very different kind of claim than acting like a bank and moving money for a fee. As the US brief explains, the payments that were made here were not payments for moving money. These were program support costs for PAHO that related to its administration of a public health program. But again, even if you accept—
Well, that's not, excuse me, but that's not what the plaintiffs allege in their brief. Is
that's
I mean, in
right.
their complaint, I'm sorry, in their complaint, that's not their allegation.
Well, Your Honor, their allegation—
And besides, don't we look at this from the point of view of the character of the commercial transaction as opposed to its purpose? And in that sense, the question is this the kind of transaction that an actor in the commercial market would participate in, right? Regardless of what its motive was.
Your Honor is correct that what matters is the commercial nature of the conduct, not the purpose. And we don't fight that rule. That's exactly right.
That's fine.
What the Congress tells us is activity that's commercial in nature is the type of activity, and this is from the legislative history, where a state-owned enterprise is, quote, carrying on a commercial enterprise such as a mineral extraction company, an airline, or a state trading corporation. Weltover, the Supreme Court's decision in Weltover, expands on that congressional guidance and says that really we're talking about commercial activity, quote, in the manner of a private player within the market.
Right.
Here, it is not even alleged that PAHO was acting as a private player in the market. What is alleged—
I don't think they have to. Why do they have to allege that? All they have to allege is a commercial, what they think is a commercial transaction. Then the question we ask, is it the type of transaction that a player in the commercial market would undertake? I don't think they have to allege the legal conclusion.
That's correct, Your Honor.
Okay.
And here the allegation is that PAHO's administration of this program and the money that it received for, and I'm quoting, brokering medical services, triangulating healthcare services for compensation, and charging fees for the doctor's labor. That is the allegation. And what we submit is, even if you focus, and again, we think you should not be focused on how PAHO allegedly benefited, but rather on the fact of forced labor and trafficking and the allegation that PAHO did benefit. But even if you focus on the how, it is not commercial for two reasons.
So wait, can I just ask you, so is it your position then that set aside the, well, don't set aside anything. Is it your position that based on the allegations in the complaint, that what is alleged is not in fact a violation of 1589B or RICO? Is that your point?
That is our belief, is what is alleged is absolutely not a violation of 1589B.
Just humor me for a minute, suppose it was. Then would you agree that this case is very different from Nelson, Sachs, and James 3?
No, and the
Really?
reason is because even if there is moving money for a fee happening in the United States, it is not the gravamen or foundation of the 1589B claim. And the reason
but let me just pursue that. In Nelson and Sachs and James 3, there was no allegation at all that the commercial transaction, the payments in Nelson, the ticket in Sachs, and the loans in James, there was no argument that those were in any way inappropriate or illegal. Whereas here, you may be right that that their allegations don't make it out to be illegal. But if it is illegal, then it's different from Nelson, Sachs, and James 3. It's different because they're alleging not just a financial transaction that's independent of what happened in the foreign country, but a illegal financial transaction, a financial transaction that violates federal law. That's completely different, isn't it, than Nelson, Sachs, and James 3?
That is a distinguishing feature. However,
Yeah.
you are still back, Your Honor, to the parameters of the commercial activity exception.
And Sachs itself pointed out that it emphasized that, look, we're dealing with a situation where, all of the cause of actions relate back to one event, whereas we don't have that here, assuming again that the allegations are sufficient to make out a violation of 1589B.
Your Honor, I don't think that's right. I think all of the claims and all of the allegations relate back to the same foundation. The foundation of the entire case, the foundation of every claim as pleaded, is that Mais Medicos involved forced labor and trafficking. The only question here is whether that PAHO's connection to that forced labor and trafficking amounted to commercial activity for purposes of the FSIA and the ILIA.
I just want to get clear. I mean, I understand your instinct to sort of roll the two issues together, that whether there's a separate financial, brokering here and the statutory question, but I really would like to have a clearer sense of your position on the statutory question. So the statute says it has a separate provision that forbids knowingly benefiting from participation in an adventure which has engaged in the providing or obtaining of labor or services by coercive means, knowing and reckless disregard that it has done so. So I understand Congress to be looking at a distinct harm there, that it's saying, knowing that something has taken place in the past, you harm the US market if you participate in commercial activity relating to that. And the question is, why isn't that different from Nelson and Sachs? And Congress has effectively defined a distinct gravamen of the domestic conduct there that just is a missing piece in Nelson, Sachs, and Jam 3. A financial benefit as the standalone violation, the financial benefit in the US.
Your Honor, under both 1589A and 1589B, the harm to the plaintiffs is exactly the same. What actually injured the plaintiffs is the forced labor and trafficking. That's
one thing
why
that strikes me as curious about this, that is clearly an injury under the statute. And it's clearly an aim of every provision of it. But one thing that's strikingly different here from in the other three cases is that this is also a criminal provision, meaning that there is a harm to the public. And the harm to the public from the benefiting from an enterprise that has used forced labor is also a harm to the market. It's unfair competition, it's undercutting, it's really distorting the US market. And why isn't that also a harm and also a gravamen in a way that the buying of the train ticket or the negotiating the employment contract or the giving of the loan in our other three cases wasn't?
Well, three answers to that. First, Sachs, Nelson, and this court's decision in Jam v. IFC all direct the court to focus on the actual injury to the plaintiff, not to society. Even if there's a harm to society from forced labor and trafficking, and of course there would be if it were occurring, that harm in this case would be happening in Cuba and Brazil. And I guess I'm not sure that the right way. Sorry, Your Honor.
But I'm sorry to interrupt, but it's critical to me to understand your point here. Could you just, why is, your point is that 1589B does not add any additional, what should I say, harm. Congress added 1589B for a reason, right? To provide a remedy for people who are injured by an entity who knowingly, financially or otherwise, participates in one of these ventures. That's why they added it. So it's different from A. And I guess what Judge Pillard and I are both getting at, maybe using different languages, the presence of 1589B and RICO in this case seems to distinguish this case quite clearly from Nelson, Sachs, and Jams 3, where you didn't have a claim about an independent behavior that itself violated federal law. And I still haven't heard.
I see. That's helpful, Your Honor. Sorry to interrupt.
No, please. Yeah.
On 1589A and B, the court is absolutely right that those were designed by Congress to reach both the entity that provides or obtains forced labor and trafficking and the entity that benefits from that providing and obtaining. And so they do reach potentially different entities. Here, PAHO is alleged to have done both. It's alleged to have provided and obtained, to enforce the terms, to engage in trafficking, and to be benefiting from that by charging a fee for its administration of Mais Medicos. What matters under Nelson, Sachs, and Jam is that the gravamen of those two for purposes of the IOIA is the same. It's the foundation of those two things is the same in the sense that they're both ultimately about the forced labor and trafficking. And if I could back
but
up.
It says knowingly benefits. In other words, so I really want to understand your point. Is your point that your client here is really charged, the one thing it's charged with is trafficking? That's it, right? Is that your point?
No, there are two claims here. There's a 1589A claim and a 1589B claim, but the 1589B claim is the only one here before this court.
Correct.
Because the district court concluded that forced labor and trafficking are not commercial activity.
Okay, now where does that
provisionally, as your opponents are very eager to point out.
Sorry, I apologize, Your Honor. Provisionally.
Where does that get you? Just keep going.
So, Your Honor, our point is that for purposes of the IOIA, the gravamen of these two claims is the same. The analysis of the gravamen is the same, and the reason is simple.
So is your point then that once the district court concluded that the 1589A cause of action couldn't go forward, automatically the B couldn't either? Is that your point? B couldn't be a separate, an independent gravamen in this case because
the elements of the two claims are different, but the gravamen is the same. And so, yes, Your Honor.
Isn't that what's critical? It's the critical difference is the elements. This is knowing participation, knowingly benefits financially. Yes. That's a separate claim. That's not the same as A.
And Your Honor, in Sachs and Nelson and Jam v. IFC, as you know, the courts were facing many different kinds of claims, all of which had different elements. And in those cases, there was, quote, separately wrongful conduct in connection with some claims that was US-based and arguably commercial. And the courts properly said that doesn't matter because the foundation is the same. Ultimately, it's all about
Are you talking about the breach of contract and failure to warn?
Yes.
But as the court said in theirs, that's just an example of artful pleading. I think that's the phrase it used. Whereas here, it's not something like, it's not artful pleading. They're alleging a violation of two federal statutes.
That was also true. That was also true in Jam v. IFC, Your Honor, where the IFC was accused of negligently financing, negligently overseeing and supervising. Those were considered completely different claims, separate from the independent actor in India.
Were they violative of federal law?
I don't know if a failure to supervise an environmental.
Was it alleged they were?
I don't think it was, Your Honor.
No, but isn't that the distinction here? I just, to me, that seems to be a major distinction between the two cases. And I still haven't heard from you why that isn't. I mean, you keep citing Sachs and you keep saying there's just one gravamen, but it just seems to me that this case is different because here, I'll just say it once more, that the financial transactions involved in those three cases were not themselves independently wrong or independently unlawful. And this one is, and that is not the situation. Sachs, Nelson, and Jams did not face the situation we face today. So the cases are different. And it seems to me the challenge you have is to tell us why that is not a material or a legally significant difference.
So, Your Honor, I think one of the main reasons that it's not significant here is that if you back up and look at the big picture of what's being alleged here, it is that the Cuban government's conscription of civil service employees and the terms of their employment amounted to forced labor and trafficking. This case is so much less commercial activity than those other cases in the sense that the entire picture of this case rests on a government's employment of its own civil service employees, its deployment of those civil service employees on a patriotic medical mission to a foreign country to serve in a public health program.
Correct.
You have
the
allegation
is that PAHO financed it.
Well,
and profited from financing it. And maybe you win on the merits on the theory you're talking about, but the question is really this threshold question where we read the pleading and in the light most favorable to the claims, and they've made they've plausibly pleaded that one of the benefits to PAHO was just pocketing a big chunk of change for doing something that these parties were aware they actually couldn't really directly do with a commercial bank, but it was the kind of activity objectively that commercial banks do.
So two things, Your Honor. There's no allegation, and in fact, PAHO did not finance this project. There's no allegation of that. The only allegation is that—
I'm sorry if I said finance, but work the transaction.
Well, and that's not what's alleged either. What's alleged is that PAHO created, managed, organized, and administered Mice Medicos, that it engaged in technical cooperation, that it engaged in everything an international organization does in connection with a public health program, and that one of the things it did was receive money from a sovereign government and transmit it to another sovereign government, which, by the way, is what international organizations do in the context of almost every public program they help facilitate.
Banks do that too. Commercial banks do just the same thing.
Well, I don't think that there's any allegation that PAHO behaved as a commercial bank in the following sense.
Yeah, but we don't have to. That's the legal conclusion.
The factual
is that they complain. They complain that that PAHO moved money for a fee.
No, they did not. I'm sorry, that does not appear in the complaint. What they say is that PAHO was paid a fee for the doctor's labor, for providing medical services, and for administering this program. The district court interpreted those allegations to mean moving money for a fee. That appears 0 times in the complaint. The other thing that is important here is that Citibank is alleged to have done the transferring of the money, not PAHO. What they say is that PAHO was an intermediary between two sovereigns. Citibank is where the accounts were. If there were fees charged, that would have been Citibank. That wouldn't have been PAHO, and PAHO had nothing to do with that. So just as a factual matter, I think it's important both to focus on what's been alleged and to recognize that there was a commercial bank here and it wasn't PAHO. But let me put that aside. In both Youngquist, this court's decision in Youngquist, and the Second Circuit's decision in Yamsostek, there were public health programs or public health insurance programs at issue. In both of those cases, the allegations were that the officials had been involved in the transferring of money, wire transfers, receipt of money, payment of money. And this court and the Second Circuit both very appropriately held that that was, number one, not commercial activity because it was in the context of a public health program. And two, that the public nature of the entire program could not be changed by the fact that some of the elements of the program have some similarity with what happens in the market with commercial actors. The point was they were not engaged in commerce. That is so true here. PAHO was never engaged and is not alleged to have been engaged in commerce. It was sitting between two sovereigns in a public health program located overseas. And it was doing what it always does, which is to facilitate the public health program to serve the sovereign member states by doing, as is alleged, managing, administering, organizing, and running this public health program. I should note also that plaintiffs have accused PAHO of enforcing the terms of employment of these Cuban civil service employees. This court said in El Haddad, and I think there's no dispute that the administration of civil service employment terms is not itself commercial activity. I also want to highlight that the same exact kinds of claims were brought in the Libyan case and were rejected as non-commercial activities by both the Southern District of Florida and the 11th Circuit in a case that was precisely the same in the sense that it was about Cuban medical missions sent abroad. I recognize Judge Pillard's concern that the way the Cuban government runs its civil service is not how the United States runs its civil service today. And I recognize the concerns regarding that civil service. I don't think those concerns, even if they are grave human rights concerns, are the types of concerns that bring this case within the commercial activities exception. And in our research getting ready for the argument, we noted that the United States in the 1960s and 70s had its own doctor's draft in which doctors couldn't choose their terms of employment, couldn't leave the service if they wanted to, and some of the other things that have been complained about here. It's not to equate the two, but rather to say that these are non-commercial activities in the core of what sovereigns do.
All right, are there any more questions?
No.
All right, thank you. Mr. Dubbin.
Thank you very much. May it please the court. PAHO fundamentally refuses to accept that Congress affirmatively enacted.
Could I ask you to just start in a different place? Could you just start with Mr. Bowker's point? I read him this quote from your brief, which is, the gravamen is moving money for a fee. That's what you say the gravamen is. And he points out that's from your brief. And actually, I remember looking at the site, and I didn't think the site to the complaint supported it. So where in the complaint do you allege that the gravamen is moving money for a fee and not other activities, namely, supporting the program substantively?
Your Honor, the complaint doesn't use the words moving money for a fee, but it doesn't have to. Judge Boasberg, who thoroughly examined the allegations of the complaint and the provisions of both statutes, took the entire corpus of what was there, including the allegations that PAHO was brought into this transaction fundamentally for the purpose of enabling it to happen because Brazil couldn't.
Well, what in the complaint,
directly.
Just could you, set aside Judge Boasberg's opinion for just a minute. We look at the complaint to see whether the allegations are sufficient. So what would you point us to in the complaint to say that this is a commercial transaction, i.e. moving money for a fee? Where do you?
Well, paragraphs 45 through 51. Paragraph 1 says that PAHO collected $75 million for taking in money from Brazil and sending it to Cuba.
Yeah, but for what
paragraph 18. That's a commercial activity, Your Honor. If you want to know about the purpose, we can address that as well. And paragraphs 45 through 51 make it clear that the reason PAHO was involved in the case was that in order for Brazil to get those Cuban doctors there, their Congress wouldn't authorize the payments. They literally, it says, and it's quoted from a Brazilian embassy quote, they suggested bringing in the Pan American Health Organization as an intermediary to enable the payments to be transferred to Cuba. And that's throughout the complaint. That's moving money for a fee. Now, when Mr. Bowker talks about PAHO receiving money from sovereign members, you know, as a normal activity, I don't think it's normal for an international organization to take $1.3 billion of trafficked laborers' wages and then send it to the entity who trafficked them. That's what PAHO did with $1.3 billion, and it put $75 million in its own pocket. And as far as the argument that went to program costs, we do allege that it did not. That's in paragraphs 87, 103, and 143.
And assuming all of those,
you.
taking those allegations as true at the current procedural stage, back to the important questions about whether Sachs, Nelson, and JAM3 foreclosed the claim on the ground that the gravamen, that we would not be here if there were not also allegations of forced labor in violation of the other provisions of against trafficking in persons. And in Sachs, the court said it rejected the notion that there was a failure to warn claim occurring in the US that could be treated as commercial activity under the Foreign Sovereign Immunities Act exception, because it said that the failure to warn was not wrongful commercial action within the United States. Now, you can agree or disagree. I mean, it seems in fact like a failure to warn for a known risk in the sale of a ticket for an activity that allegedly exposes the ticket holder to that risk. One could say, well, that's a wrong in the United States, but the court in Nelson said no. The court in Nelson said the gravamen was the harm to the plaintiff overseas. Why are we not in the same situation here?
As Judge Boasberg pointed out, a case can have two gravamens. He determined that the 1589A claim was not a commercial gravamen, but he clearly said that the 1589B claim is commercial and is a self-contained wrong. As Your Honor pointed out in your questions to the appellant, 1589B makes it a crime to knowingly benefit from participation in a forced labor venture. And that's what we have alleged PAHO did. And Judge Boasberg, cited footnote 2 in Sachs, which makes it clear that in another case based upon A2, where the gravamens might have occurred in two places, we would be in a different place. That basically anticipated our case. Our case is a self-contained wrong by PAHO violating 1589B, as Judge Boasberg meticulously documented in his analysis, which is entitled to deference. We're here on a 12B6 standard, and yes, we're entitled to the benefit of
de novo review.
De novo review, but we're entitled to the benefit of every inference in the complaint. And Judge
we also apply that standard and make those inferences. But so I'm just, help me out, because it just seems that it has to be true here, as in Nelson, that the allegations about the commercial part in the United States would alone, as in Nelson, entitle Nelson to nothing without the allegations of, in Nelson, the personal injury abroad, and here the forced labor abroad.
Your Honor, this is a separate wrong, okay? Taking my client's money and putting it in your pocket, taking my client's money and sending $1.3 billion to Cuba, okay? That all happened here in the United States, and that's what PAHO did. And Congress specifically added 1589B in 2008, as the Congressional Amicus Brief shows, as the Trafficking Victims Legal Center's brief shows, specifically because just going after the trafficking itself was not doing the job of eliminating the problem. So we have a separate gravamen here that PAHO profited from its knowing participation. Now, Secretary of State Blinken has stated for the last 10 years that that Cuba's medical missions are trafficking and are for Cuba's profit. And knowing that, PAHO knowingly got involved in this transaction and profited from it. That's a separate violation of 1589B.
Well, this is where I'm struggling, because there was a separate violation of law alleged in Nelson. In the recruiting of Mr. Nelson in the United States, the defendants omitted important information about his prospective employment. And the allegations were that it knew or should have known that as somebody who's being hired to do quality control for a Saudi Arabian hospital, when they try to actually criticize the safety and quality in that hospital, is going to be severely punished. And so the allegations are that omitting that important information during the recruiting was itself a separate harm under US law. And the court said, no, gravamen in Saudi Arabia. And I'm just looking for distinctions between that and this case.
The gravamen of a violation of a statute that makes it a crime to knowingly benefit from participation in forced labor is knowingly participation in a venture that's forced labor. And that's what we've alleged PAHO did. That's a self-contained gravamen. Whatever Your Honor thinks about the result in Nelson, we have a self-contained gravamen here under a statute that Congress specifically enacted to capture this very activity. That's the reason we have 1589B. The complaint clearly alleges that PAHO knowingly pocketed $75 million it knew was money from the wages that were owed to my client. That's a crime, and that's something where there's a civil right of action. I'd like to make and I would analogize the Judge Boasberg's conclusion about the gravamen to this court's decision in De Scheppel, when the government of Hungary argued that the plaintiffs had not alleged that Hungary promised to return that property to the United States. And this court said that it was a fair inference from the facts alleged in the complaint, which were that Hungary promised to return the property to the plaintiffs and knew the plaintiffs lived in the United States, that was going to have a direct effect in the United States. We're entitled to the same benefit of the inference here that Judge Boasberg drew from the allegations in the complaint. I'd like to briefly comment on the government's brief because they agree with the plaintiffs that the World Health Organization Constitution does not provide immunity to PAHO. They acknowledge that they don't have a position on whether or not PAHO's money, the money PAHO received, was used for program expenses. But they.
I'm sorry. Would you just repeat what you just said? I'm sorry. You clicked out for a second. What did you just say?
That the government, we agree with the government that that PAHO is not entitled to absolute immunity under the World Health Organization chart, and that position of the government is entitled to deference.
No, I heard that, but what was that about money you just said?
That that they don't take a position on whether or not the plaintiffs have adequately alleged the nature of the money that was received by PAHO.
I see. Yeah,
they don't take a position.
Okay.
So our position is that this is not before the court. The complaint does allege, as I stated before in paragraphs 87, 103, and 143, that none of the money that PAHO received was used for program expenses. And there's no reason for the court to venture into that here. If the court were so inclined to ask the government there's no application of that argument, they don't talk about how that would affect this case. And so if the issue is that PAHO's receipt of $1.5 billion from Brazil and sending $1.3 billion back to the trafficker is a program expense, that's not tenable. If their argument is that some of the $75 million that PAHO received and put in its pocket was used for, quote, program expenses, that would be an argument about purpose and would not be relevant to the jurisdictional determination.
Mr. Dubbin, you're over your time.
Thank you very much.
And we'll hear from Mr. Yellen.
Thank you, Your Honor. Good morning, Your Honors, and may it please the court, Louis Yellen from the Department of Justice here today on behalf of the United States. As the court knows, the United States is here for a very limited purpose to address one issue that the court may have to consider, that is the non-commercial nature of an international organization's receipt of program support costs from a member state. The basic principle that we urge is that if the program itself is public, then the money paid by a member state for program support costs is also public. Now, the parties have taken different views about what the government's brief has said, and they're not exactly right. And I'd like to clarify this because I think it goes to an important part of the court's colloquy earlier in the argument. It's not the case that the government has endorsed the idea that the payments here were part of program support costs, but it's also not the case that the United States has not taken a position on whether the plaintiffs adequately alleged that the payments were not program support costs. The point, I think, that are—
In other words, you have not taken a position on whether they've adequately alleged?
The question isn't one about allegations, and this is the critical point that I'm hoping to be able to explain to the court. The question about whether or not payments are part of program support costs is part of the immunity question. It goes to the commercial nature of the transaction. Let me give you an analogy. Recall that the IOIA tracks the FSIA's commercial activity exception. Now imagine a foreign sovereign paying one of its agencies, providing it in its budget funds for the payment of contractors to provide medical services. If a plaintiff sued the foreign sovereign on the theory that the foreign sovereign's payment to the agency was commercial in character, the court would have to consider the nature of the program, that is, the nature of the enterprise that the foreign sovereign and its agency were undertaking. Just so in the IOIA context, the question is, if an international organization receives from a member state payments of program support costs in connection with a public program, those payments are also public. That is, they're part of the public, that is, non-commercial enterprise in which the international organization is engaging on behalf of the member state.
Okay, so from the US's point of view, what's the question we should ask here?
The question is whether—
the question that we should ask about this case.
The question that this court needs to consider is whether the district court properly determined that there was a commercial activity at issue here.
Yeah, I know that.
Well, I'm sorry. I had a comma there, Your Honor, and
okay,
I didn't quite finish the thought. And part of that inquiry involves, in the context here, determining whether the payment was in part of program support costs on behalf of a public program that PAHO had undertaken on behalf of member states. The court, it's not sufficient to release—
At this stage, isn't that just a question of looking at the complaint and seeing what is alleged?
No, Your Honor.
No?
A court, in an immunity matter, a court cannot turn to the merits until it has determined conclusively that the international organization—
No, I wasn't talking about— No, I'm sorry. I didn't mean to say look at the merits. Just look at the allegations of the complaint to see what the allegations are with respect to whether the money is part of a program or whether it's a fee of some kind.
That's right, Your Honor.
Don't we just look at
the question would be, well, what's next, Your Honor? Let's assume that as a pleading matter, the court determines, okay, there's an allegation that this enterprise, that this payment was commercial. Well, the international organization or a foreign state disputes that, right? The question is, you don't get to then go on to a merits determination because the court has not yet adjudicated fully the immunity or jurisdictional question. So it is incumbent on—
I'm sorry to interrupt. I just want to— Is what you're saying that the next thing, assuming, let's say we're not involved in this and Mr. Bowker didn't appeal, the next question in the district court would be, before you get into trial on the merits, we want to do a trial on those facts that go to whether the allegations about pocketing a fee are supported. So let's focus at the front end and actually have a final factual determination, subject to clearly erroneous review, whether there was some kind of sweetheart deal where PAHO is profiting off of forced labor, or whether when PAHO opens its books, we see it's running a program, it's doing support costs, it's paying its people for overseeing all of this stuff. And if the latter, then immunity actually at that later point kicks in. Is that your position?
Maybe, Your Honor. And let me clarify what I mean by maybe. The further inquiry may not require a trial on the facts of jurisdiction.
It could be in a summary judgment posture.
Exactly. The only point is the court would be looking outside of the pleadings. And just as in the Supreme Court's recent decision in the Helmerich and Payne case, a district court has to decide at the outset whether the requirements for immunity have been satisfied or not. And that is something that has to be done before the court gets to the merits. There is a dispute in this case. The dispute is something that the United States has not taken a position on. There's a dispute about the nature of the particular transactions and their connection or not to a public program.
That makes sense. So what you're saying is that even if pleadings are adequate, there continues throughout a case a kind of priority on the factual assertions, then turning into evidence, then turning into findings of fact, should, God forbid from PAHO's perspective that have to go that far, but that there should be a priority at each stage in verifying whether the key facts that support the commercial activities exception are materializing or not.
I think that's right. The only qualification I would make, Your Honor, is that it may not be purely factual. There could be legal components to the inquiry as well, depending on the nature and the structure of the international organization. It's set up pursuant to its organic documents with the member states. All of these things may be relevant to the nature of the setup. But the bottom line that I would wholly endorse, Your Honor, is that before a court were to reach the merits of a claim against an international organization, it would have to be sure that the claims actually satisfy the requirements of the commercial activity exception. That requires not only that the claim be based upon certain action, that is, that the gravamen of the claim be based upon actionable claims, but that those actions on which it's based upon are commercial in nature and not public.
Mr. Yellen, I just have a simple question. I just want to make totally sure I understand the United States position. We have this on a motion to dismiss, right?
Yes, Your Honor.
Okay. So we look at the complaint, right? And we ask whether the allegations are sufficient, giving the benefit of all inferences to the plaintiff, correct? And if we decide they are, then your point is PAHO could still file a motion for summary judgment, and that would require that the allegations be proven before the court can make a judgment on immunity, correct? Do I have it?
Yes, I'm sorry. I'm thinking through this, Your Honor. I believe that's correct.
Okay, thank you.
And it might present, as you're pointing out, whatever the legal issue is that we decide is decided on the basis of whatever the facts are at the relevant stage. And so here, the plaintiffs have alleged something, and we could decide a legal question. The legal question we might be deciding at summary judgment might shift because the facts that are evidenced to a level sufficient to create a triable issue might be different. So they might have a more challenging legal argument at the summary judgment stage, a distinct and more challenging argument. So it might not be law of the case, and it might require some different legal analysis. Is that what you're saying?
That might be right, Your Honor. I guess the only qualification I want to give is international organizations are not like commercial enterprises set up by states. They're international organizations, by their very nature, deal with public programs on behalf of their sovereigns. And so it would be the extraordinary case that would get very far. And the court needs to be, I think, cautious about the potential for artful pleading to string out litigation against a international organization, given this background, given that the typical conduct in which international organizations engage is public and not commercial. This is something the court needs to be cautious about. And I want to be very clear that we are not signaling anything about the underlying case here. It's just a general concern that the United States have about the nature of international organizations and the public programs and the payments that sovereign states make to those organizations that are roughly analogous to payments that sovereign states make to their non-commercial agencies. The rule that the court lays down here will have implications not only for international organizations and conceivably have an impact on the United States funding of international organizations, but also conceivably could have an impact on the commercial activity exception under the FSIA.
All right, if there are no more questions, Mr. Bowker, why don't you take 2 minutes?
Thank you, Your Honor. I'll make just a few quick points. First, PAHO's position is that this is resolvable on the face of the complaint, that PAHO's immunity is immunity not only from liability, but from the burdens of litigation. The reason it's resolvable on the face of the complaint is the complaint alleges that PAHO was paid in connection with its administration of and enforcement of the terms of employment of this Cuban medical mission and Mais Medicos. I'll point the court to paragraphs 1, 6, 19, and 38, all of which explain that PAHO was being allegedly paid for labor, for medical services, and for its, quote, enabling, managing, and enforcing of this trafficking.
What were those paragraphs again?
It's 1,
Read them in a
1, 6,
6,
19,
uh-huh.
and 38.
Okay, thanks.
And I'll repeat what I said earlier, which is that moving money for a fee does not appear in the complaint. The second point is in response to my colleague's point about expenses versus program support costs. We're not fighting with the allegation that PAHO didn't pay for out-of-pocket expenses, things like travel, food, lodging. We're not fighting with those allegations. The point here is the point that the United States government brief explains in great detail, which is that program support costs are different. Those are for indirect or overhead costs. They're standard for all public programs for IOs, and those are different from the out-of-pocket expenses that my colleague, Mr. Dubbin, was referring to. And so we don't fight with those allegations. The third point, and this to Judge Tatel, I know that you were focused on the difference between the type of claim in Nelson and Sachs and the one here. And I just wanted to direct Your Honor's attention to 136 Supreme Court at 396 in Sachs. And I'm going to quote here where it says, under any theory of the case that Sachs presents, however, there is nothing wrongful about the sale of the Eurail pass standing alone. And then there's an ellipses here. However, Sachs frames her suit, the incident in Innsbruck, that's the platform in Austria, remains at its foundation. And that is true here. Standing alone, the alleged moving of money that occurred in the United States is not wrongful. The only thing that
that's because it's program support under your theory, right?
No, whether it's moving money for a fee or whether it's program support costs for a fee or whatever, however it is framed, it is not independently wrongful without a connection to forced labor and trafficking overseas. That aspect of our case is exactly the same as Sachs and Nelson and Jam. And I think that's what's critical here for purposes of the commercial activity exception.
All right, if there are no questions, Madam Clerk, if you'd call the next case.
Case number 20-1495 et al. Duke Energy Progress LLC petitioner versus Federal Energy Regulatory Commission. Mr. Zetlin for the petitioner, Mr. Ediger for the respondent.
Mr. Cheslin, good morning.
Thank you, Your Honor. Misha Tsaitlin for Duke. FERC's orders below rewrite the full requirements contract between Duke and Power Agency, permitting Power Agency to implement a scheme to eliminate its contributions to Duke's fixed costs by deploying grid-scale battery devices to service the retail energy needs of Power Agency's customers, precisely on a contractual event, one particular hour per month. This, we would respectfully submit, is a straightforward case of contractual interpretation, reading primarily just two provisions of the contract here. Our position is that Power Agency's deployment of grid-scale batteries to service its consumers' retail demands is not within the contractual text for demand-side management or demand response, because the contractual text requires that both of these concepts are limited to modifying consumers' patterns of electricity usage.
Where does it state that in the language of the contract? I know that's your position. I know your position is that it requires actual production. It requires actual reductions in energy consumption and affirmative acts by end users. But where is that in the actual language of the contract?
Right. So let's I'll talk about demand side management first, and then I'll talk about demand response.
Okay.
With
Great.
regard to demand side management, it is the definition of demand side management, and I'm going to quote the language. Demand side management is defined as, quote, energy and load shape modifying activities that are designed to encourage consumers to modify the patterns of electricity usage. So there, the requirement is that the consumers modify their pattern of electrical usage. Here,
it wouldn't be a problem under that provision, Mr. Sitlin. It wouldn't be a problem if the Power Agency loaned to its largest retail users the batteries and said, here, put these in your, let's say it's a Walmart or something, put this in your electrical intake, and we're going to signal you when to use them, and it'll change your pattern of electricity usage in a way that's going to lower everybody's rates. That's not what they did here. But that wouldn't be a problem under Article 1.47 defining demand side management, would it? That's just not what happened here.
That's right. That would be a different case. Situations where retail consumers self-supply their own energy rather than Power Agency
Well, they're not supplying it, but they're storing it and therefore modifying a pattern of usage, including the timing of demand. So the overall demand would be the same. Nobody disputes that here.
Right, Your Honor, that would be a different case. That would be outside of what the order is here, and I don't think that we need to prejudicate that. Situation here is that the consumers are doing nothing. The consumers.
Right, now talk about 9.5, because it doesn't have that encourage consumers language. Under 9.5, I think the best argument for your opponents is that nothing is intended to preclude the Power Agency from taking steps to manage or reduce members' demands and or load through the use of pricing information. And that's obviously taking out the communication to consumers, but there's sort of two separate pieces of that clause. And why isn't this within managing demand or load through the use of pricing information on Power Agency's part?
Well, Your Honor, I think you just answered your own question, is that would take out that other aspect of the language, is it's the use of communicating pricing information to consumers. So
no, it's the use or communication of pricing information to Power Agencies or its members, customers.
Yes.
So communication of pricing information to customers is one aspect, but the use it can't be the use to customers, is it? It's the use of pricing information or the communication of pricing information to customers.
I think it's pretty clear from that language, which isn't, the best drafted language, that it's
No, it's not.
the use by the customers. And I also say that
How do customers use pricing information in that?
Well, so let me explain, Your Honor, and this is the way these work. So the customer will sign up for a demand response program, which will send to an app on their phone that'll say, oh, look, it would cost you a lot of money to run your washing machine right now.
No. This is actually a point of contention or confusion that I have from the briefs. The retail price, the whole structure here is that the retail price doesn't go up and down. And so it's those who have contracted to provide the energy that are worried about saving costs at peak, because the retail customers, they're not going to pay more at peak.
Well, Your Honor, I think that's not a correct understanding. The customers, there could be variable pricing on the customer side, and so the whole
point. Is there here? I thought the whole structure was that retail customers have an upfront contract for fixed price, and that creates this sort of lack of supply and demand pressure. It's not costing them more on the peak days. If it were, then the problem would resolve itself because they wouldn't use as much energy on peak days. But that customers are kind of indifferent as to whether it's a peak day or not because they're paying the same amount. No,
I don't believe that's right. I believe a demand response program is created is so that the customers can ratchet up, that they can be given savings for
at the behest of the power agency, because the power agency says we're absorbing this cost in order to align your incentives, ultimate consumer, with ours. We're going to sweeten the pot. We're going to pay you $60 a year if you agree that on a couple peak days we can duck in and turn up your thermostat. That's right. How I understand it, and that they need to do that because the otherwise the incentives aren't aligned. Am I wrong about that?
So that's more demand side management. That's when the customers sign up for a program where power agency can turn up off and on their thermostat in exactly the way you described. The way the demand response works is that the customers are given a financial incentive to do that themselves. They get pricing information. They say, oh, well, if I run my washing machine at 6 p.m. when everyone's got their lights on, everyone's cooking dinner, everyone's watching the TV, I'm not going to get that discount. But if I run my washing machine overnight, because I got this pricing information, then I'm going to save a bunch of money, because that is the way the demand response works. But again, that is the fundamental point here, is that the consumer's got to do something. The entire structure of both 9.4 and 9.5 is the consumers shifting the time when they use electricity and shifting their consumption. What happens with the deployment of grid scale batteries by power agencies is the consumers are doing nothing. They are blissfully ignorant. They turn on their lights, they turn on their TV, they run their washing machines all at the same time. They couldn't care less. They're not communicating in any way that whether they're getting their retail power as a pass-through directly from Duke's utility at that moment, or if they are getting their power when they turn on their light switch from grid scale batteries run by power agencies.
So it's your position that just as a factual matter, there isn't a way that a power agency could use pricing information itself to reduce members' demands or load, that just isn't a category of, so whatever ambiguity there is in the language, it just couldn't refer to that because that isn't an action.
I mean, certainly by the fact that power agency has that information, it can use its powers under demand side management if someone signed up for a program to ratchet off and on the thermostat. But with regard to demand response, that's not how it operates. Sorry, Judge Tatel.
Your whole argument is that this contract's clear. Suppose we think it's not, and we owe deference to the commission, even on the question of whether it's ambiguous. And so just suppose, for argument's sake, we think it's not as clear as you think, and that there's ambiguity in this contract. Can you prevail at that point? Or does your whole argument depend on your claim that this contract is unambiguously clear?
Absolutely, Your Honor. So
absolutely what?
I I'd like to quibble with the premise here of your question and then answer it directly. I think it's fairly clear from this court's cases, such as Cajun, that if the contract is clear, this is just a Chevron step one issue, and you don't give deference to an agency on Chevron step one. And this is an analogous.
No, I didn't say we did.
Oh, I apologize.
I'm asking you whether or not, if we think it's not clear, what's your best argument that the commission's interpretation of the contract is unreasonable?
I think, Your Honor, in that sort of circumstance, we would be in a Chevron step two world. And under this case, this court's case law, including the recent decision in the ACE case that Judge Pillard was on, if the agency does not show that it is exercising some sort of discretion, it's not recognizing an ambiguity and then attempting to resolve it, then the agency cannot prevail under Chevron step two or this analogy under the Chenery Doctrine. You cannot, for example—
You don't think that's what the commission's brief does?
I don't see the commission's brief as arguing anything except for the meaning of the contract. But if Your Honor do read its brief that way, then I think that it would be foreclosed by the Chenery Doctrine, because they did not, in their orders on review, say, well, this contract is ambiguous, Chevron step one. Now we're going on to Chevron step two, and we're going to use our policymaking authority to resolve that ambiguity. They did not engage in that kind of inquiry, and so under Chenery, their decision cannot be upheld under that ground. If Your Honors think that the contract is ambiguous, contrary to our submission, then I think the only resolution of this case is to vacate the underlying orders, send it back to the agency for the agency to resolve any ambiguity that this court would identify in the contract.
I have some practical questions trying to understand, and maybe these just go to the equities of the case, but how much of the total power demand comes from power agency? One thing that I wondered about is whether it's possible that by discharging their batteries at the hour they think is going to be the peak, they're going to actually prevent that hour from being the peak because it's a feedback loop.
Your Honor, I don't believe it's in the record, but they're about 10% of what Duke outputs, and there's nothing in the record that I know that would answer your question any further.
And is the battery capability big, or how marginal is that?
I believe this is all in the nascent phases. I believe they're asking FERC to approve this so they can then deploy these grid scale batteries at a very substantial rate. And our primary concern here is they're going to deploy it at such a rate that they're going to completely eliminate their contribution to our fixed costs. So that was my other question about fixed costs. The capacity charge, is that the only place that fixed costs, or is part of the energy charge also includes some element of fixed costs? Because in the past, I had thought the capacity was really about future capacity, but I know different markets are structured differently. And you had made a pretty bright line distinction between capacity charge as the only place where power agency contributes to a pro rata share of fixed costs. Is that accurate? My understanding, Your Honor, is that the energy costs under this contract are a complete pass-through. We made that argument repeatedly in our submissions before FERC, and as far as I can tell, nobody disputed that claim that the energy cost here is a complete pass-through, and the entirety of our capacity costs and the entirety of our profit. This is a capitalist system. All come from the capacity charge, which they could.
But does the pass-through not include? It doesn't include amortization of existing facilities as distinct from capacity, which is about sending signals to build future.
That's right, Your Honor. My understanding is that the energy charge is a complete pass-through.
But pass-through of what? I'm asking whether isn't it also pass-through of some amortized asset costs?
I believe is not, but I will correct myself on reply if that is incorrect.
Okay. And it's not typical necessarily that peak demand is determined from one day. I mean, under some regulatory systems, it's sampling across different periods. It's just the way this contract is written.
Your Honor, I'm not familiar with the broad range. The FERC does say in its order that this is something that is done from time to time on a somewhat basis, and it operated. It's important to understand that hour is a contractual proxy. No one believes that it only matters how much they draw on us 1 hour per month, and it's a contractual proxy that works well within the confines of the contract. What they're attempting to do here through the deployment of grid-scale batteries is destroy the economics of the entire contract by timing their supply of retail energy just during this 1 hour. They are basically becoming free. They can give themselves the authority to become complete free riders off our system, where they're only paying the pass-through and everyone else, including us, is bearing the capacity costs and, of course, no profit for us.
All right, if there are no more questions, Mr. Ediger.
Who on my screen seems frozen.
Good morning, and may it please the court. I'm Scott Ediger for the Federal Energy Regulatory Commission. Thank you for hearing the case today. I'd like to go to the standard of review and address Judge Tatel's point about if, I certainly understand that there's a disagreement about whether the contract language is plain, but in at least 2 places of Duke's reply brief, they suggest that they have the more reasonable interpretation of the contract, and I would submit that implies that there is some reasonableness to the.
Well, what about counsel's argument that FERC didn't anywhere in its brief indicate it's exercising its authority to interpret the language?
I would point to this court's decision in National Fuel, which talked about the question here is whether the contract has directly addressed the precise question. And
no, I understand that, but his argument is that in FERC's brief, the agency did not, in FERC's decision, I'm sorry, the agency did not claim to be exercising its discretion to interpret the contract.
I think the only reading of the commission's orders is that it did just that. Battery storage technology is not addressed. As we all acknowledge, even Duke acknowledged that it's not addressed.
Right.
Contract. The commission's only reference to plain language in declaratory order and in the rehearing order was to reject Duke's position that the plain language leads us to the outcome that it prefers. The commission also explicitly in paragraphs 38 of the declaratory order, this is at JA 24 to 25, said that key terms of the contract are not defined, and that's demands and loads. The commission also discussed that in the rehearing order at page 14.
Let me ask you, Mr. Ediger, about this issue that came up with Mr. Setlin about the Article 9.5 definition. First of all, I don't know if you read it as I do, that it's susceptible to be read that it allows the power agency to manage or reduce members' demands and our load through the use of pricing information or the communication of pricing information to members' customers, to agencies or members' customers. First, is it in fact ambiguous in that way in your view? And second, if so, does the power agency use pricing information itself to manage or reduce loads?
It does. I will concede that this isn't the best drafted language, but I will make one point. The municipal agency doesn't have customers other than the municipalities.
The members.
If that's to have any meaning whatsoever, what we're talking about there is the municipal agency's use of providing the information to the members.
Okay.
Their use would qualify as demand response under section 9.5.
So it's through the use of pricing information by power agency or the communication of pricing information to the power agency members' customers. And my question is, just as a factual matter, is there such a thing as the power agency's own use of pricing information to manage or reduce demand?
I think that's something that is contemplated here, that the agency is contemplating. I don't know whether they have actually done that here, but that's what they're asking for.
By the use of the batteries.
Yes. And
are there other programs that have that track the language in that same way?
In other
that don't have to do with communicating the information on to customers and having them react, but having Power Agency itself use pricing information itself without communicating on to customers to use pricing information to manage or reduce demands or load.
Well, and again, I think here what the commission was getting at was that the agency was communicating that information to the members, to the municipalities, and that they would use it to reduce the load on the system, and from the perspective of Duke's system.
But not to the members' customers?
Correct.
Why do they need to communicate it to the members if there are steps that the Power Agency itself can take? I guess is what I'm asking.
Well, I'm not sure I follow. I'm sorry, Your Honor. This language is difficult. I think, and again, the Power Agency doesn't have customers, and I think what's contemplated here is that they would pass this information on, the pricing information that they're entitled to under Section 18 of the contract, to the municipalities that would use the information to operate the battery storage technology.
Okay, I just thought that you had said that how you thought this provision, 9.5 demand response, authorized the use of the batteries. Nobody's saying that that information is passed on to customers in the process of using batteries to manage demand or load, right?
I think that's correct.
And the question is, therefore, do you read this contract to allow that because you read it to allow the Power Agency to manage or reduce the members' demands or load through the Power Agency's own use of pricing information, as opposed to the Power Agency's communication of pricing information to members' customers? And I thought you said to that, yes. And I was asking whether there was any precedent for any other kind of management or reduce of demands or loads on the part of Power Agency that would similarly not involve communication of pricing information to customers, but simply the use of pricing information by the Power Agency.
I'm aware of none, Your Honor. And what I think is key to this section is it's the manage or reduce the members' demands, not the end users' demands. And I think that's what Duke is asking for here is a simple backing up a few lines in that section. And this is the same language in 9.4, is what they're seeking is that a rewrite of the contract such that the contract only permits managing or reducing the end user's demands and or loads. And that's not what the contract says. The contract speaks in terms of the members' demands or loads. And I think this is the language that the commission was grappling with, is determining from what perspective we look at demand. And that's what led the commission to, as I was saying before, those terms are not defined in this contract. And that's what led the commission to look at the definition of hourly demand in section 1.77. And I also want to highlight section 9.3. This was important in the commission's analysis. We're talking about consumption and getting back to my comment about perspective on whether this contract requires the customers to do anything. And that section is very clear that it is talking about actual consumption. And I would suggest that's by negative inference. That means we're talking about something very different in sections 9.4 and 9.5.
What's your response to counsel's argument that what the commission has done here is completely blown up this contract?
I would disagree with that, Your Honor.
I thought you might. Why?
There's no record support for that. The idea that something cataclysmic, disastrous has happened here, I'm aware of no record support for that argument.
Well, because nothing's happened here yet. It's all about approving something that might happen in the future.
That's correct, Your Honor. And I would point out as well that the commission addressed this in rehearing, and in particular, the last two paragraphs of the rehearing order, paragraph 15 at JA 33 to 34 and paragraph 16. This contract.
What did it say there?
I'm sorry, Your Honor.
I'm sorry, what did it say there?
It addressed the idea that this contract permits a revision if Duke doesn't believe.
They can come back to the commission. This paragraph 16, right?
It's actually 15 where we cite section 8.
I was close. Yeah.
Of the contract, and that's at JA 194. Yeah.
You mentioned that 9.3, but did the commission's order rely on 9.3?
It did, Your Honor, and it did in paragraph 38. This is at JA 24 to 24.
Right.
And I believe it repeated that similar analysis hearing order, in particular paragraph 14 of the rehearing order at JA 33. This gets very short shrift attention in the Duke's briefs, and I think it's a very telling provision for understanding why reduction of consumption was not contemplated in these two sections. And I think the commission was on firm ground in rejecting that argument by Duke for that reason.
All right, if there are no more questions, why don't you take 2 minutes and reply?
Thank you, Your Honor. Just 3 brief points. First, Judge Pillard, I was correct that the energy charge includes only the pass-through amount and maintenance, no amortization of fixed costs. With regard to 9.3 that my friend just mentioned, that's energy efficiency. That's like installing more efficient light bulbs. That has nothing to do with demand side management and demand response, which is modifying the patterns of electrical usage. Power agency taking over your thermostat, turning it down, turning it up, or them sending you pricing information so you can run your washing machine overnight and things of that sort. And then the final point that
when you talk about power agencies taking over your thermostat, is that under Article 9.5? Isn't that the kind of thing where it doesn't need to on that in real time communicate information to consumers? It just needs to react itself to what it knows is a coming peak and take action based on other information it's collected in the past.
That's 9.4, Your Honor. That doesn't involve any communication of pricing information to the consumer, but it does involve a consumer signing up for a program that will modify the pattern of the consumer's usage. So the thermostat where power agency uses, in the words of 9.5 or the definition of 9.5, 1.47, centralized control. That's what that means. And so the customer says, yes, I want to save some money, power agency.
So give me, in your view, the classic example of demand side management and the classic example of demand response.
The classic demand side management is what I was just describing, Your Honor, where you allow power agency to control your thermostat or to pre-cool your building before they know a peak is happening. That is classic demand side management. Classic demand side response is you get an app on your phone that tells you if it's going to cost you more, you as the consumer is going to cost you more money to run your washing machine now. And you look at your app and say, oh, look, it's going to cost me, I'm going to save some money if I don't run it now, if I run the washing machine overnight. So you yourself decide not to run your washing machine now, you run it overnight because you've gotten some pricing information from power agency.
I should have asked Mr. Ediger this, but I just don't think you're right that consumers' prices fluctuate based on the day or time of day that they're using energy.
I believe that the way the demand side response program works is that they give you that information, they give you a price, they give you financial incentives to do that precisely. They give you savings to if you so choose on yourself to not run it at a certain time and run it at other times. And then the final point, Your Honor, this is the one you've asked about. I just don't think about 9.5 and the word use. I just don't think that textually works, and it wasn't certainly a textual analysis that FERC did here. I think you would say you would have to kind of take out or communicate pricing information. And,
well, you use it as an alternative, which is what or denotes.
Through the use of pricing information, but then you would take out the back end of it. You basically, as I understand that reading, and it wasn't presented by my friends on the other side, is you'd say through the use of pricing information, but then you would take out the end of it. And so then you would have a sentence that's kind of like split into two and rewritten. And I would say, Your Honor, that's creative. But I think that is outside the bounds of traditional understanding of text. And I think that, and it certainly wouldn't get the agency beyond the equivalent of Chevron step 1. And for those reasons, I would urge Your Honors to vacate the orders below.
All right, thank you. Madam Clerk, would you please adjourn court?
This honorable court is now adjourned until Friday, October 5th at 9:30 a.m.